Right, should we get going on this then? Hello everyone. I believe there's a number of you in the meeting now. Welcome to the IR35 webinar with Xcede and JSA. Hopefully it's going to be a good forum for you guys to get a bit of an understanding about IR35 from the basics through to risks and how you can prepare for the changes that are coming in April. So I suppose I should introduce myself. My name is Martin Caswell. I'm the Associate Director of the UK contract team, about 10 years contract recruitment experience. Yeah, we're now partnering with JSA to help our clients sort of with the upcoming changes and, working with them to hopefully mitigate as much risk as possible and keep our sort of clients and contractors as informed as we can. There is a section for questions at the end. So if we could just put them all in the chat box. I believe everyone is auto muted. But if we just stay muted and put questions in the chat box at the end, Natalie and Chris will be able to answer them. There'll be a big section on it. So hopefully once all the info's through, we'll be able to have a really good Q&A towards the end for this. So just going on the agenda for today, we're going to be briefly go over Xcede and TechStream as an introduction. I'm then going to pass it on to Alex Marshall, who is our legal governance manager, who's going to give you an overview of IR35 legislation as a whole and come into the private sector and give you a bit of meat on the bone, so to speak, and sort of a ground up on the basics. We'll then be able to talk you through with Chris James, who is the director of JSA umbrella company, and he's also the chairman of the FCSA, who is, I don't know if you know who the FCSA are. They're the leading membership body for sort of supply chain compliance. So he's going to be able to talk you through the risks and what the new IR35 legislation means for your supply chain, and how you can hopefully mitigate risks and understand it in a lot more detail, what it's going to mean for you. And then, as I said, we'll be able to go through and talk Natalie and Chris and answer your questions as we go along. So just a very brief overview of Xcede. So Xcede is a digital recruitment company. We've been in the market for 15 years. We have 150 contractors within the UK, and we work across the full digital life cycle, be it from design through to development, analysis and customer retention and acquisition. We recently were merged with a larger global business called the TechStream Group, which has grown our contractor book to 350 in the UK, 600 worldwide. It's allowed us to cover markets such as cloud, cyber, data automation, renewable energies. I think what this means sort of for our clients and our candidates is the fact that we are now offering them a much more mature service, and we'll be able to guide them with their contractors. We are a company that has kind of been there, done that, and has a huge contractor population in the UK. That partnered with JSA's experience of dealing with contractors, contractor migration, and their experience around legislation, hopefully means we can provide an amazing service for our clients. So I will pass you on to Alex, who is going to go through IR35 in a bit of detail for you. Thanks, Alex.
Thanks, Martin. So good afternoon, everyone. As Martin has just said, my name's Alex Marshall. I'm the Group Corporate Governance Manager here at the TechStream Group, which is Xcede is part of, and I'm helping out with the legal and compliance side of IR35 for the group as a whole. So I'm going to give you a little run through of the legal guidance and provide some updates of the legislation that has changed or been updated in the last 12 months since we've had this 1-year grace period to kind of keep moving. Okay, so a little bit of an introduction to HMRC and IR35. So they introduced IR35 in 2000, which was a way of tackling what they referred to as disguised employment. So it was a way of stopping people who were basically working as an employee, but getting the tax advantages and efficiency of working through their own limited companies. There's a lot of benefits to working this way. So employers don't have to pay national insurance or contributions or employee benefits. And as I said to the consultant and the contractors, it's all about tax efficiency. But for all intents and purposes, It's when you're taking on work for other clients, and that's how it's assessed. So if you're assessed as a contractor who's inside IR35, basically for tax purposes, you're an employee, and you're going to face income tax and national insurance burden just as any other employee do. So if you're outside IR35, you don't do that. So the legislation can be a little bit complicated. Even HMRC have said there's been a little bit of a struggle about it. And there's been lots of IR35 cases at tribunal, and fighting it has been difficult and patchy. So the lack of clarity has caused a lot of ambiguity over employment status guidelines, including employment rights and if they're inside IR35 or not. So it's been a big controversial introduction to the guidance as it's been rolling out over the past 20 years. So I'm going to give you a really brief overview because I'm sure everybody is incredibly familiar with how IR35 works in theory. So we'll just run through this really briefly for you. So IR35 applies when it's a contract or an engagement, and it's saying they must work out the employment status of the person providing the services. So you're assessing the services. HMRC say that off-payroll rules apply if the contract would be an employee if there was no intermediary. So if that's like a limited company, a personal service company, if that wasn't there, would the work that the person doing make them an employee? And in some cases that will be yes, some cases that will be no. So intermediary is a bit of a delicate term that has been updated, but I'll come to how that's been updated towards the end of this presentation. So it's called IR35, which is intermediary legislation, and it applies to people who are working through an intermediary, kind of the middle ground, not as an employee for a client or a company. So it can be like their own limited company or a personal services company where they are the sole director, they own the majority shares, and then they deliver a service to a client. But other things that can be intermediaries can be a partnership or another personal services company or an individual. And contractors can provide services directly to clients through their intermediary, or they can work through something like Xcede, like an agency. So status of what IR35 kind of works as is all down to some key tests that HMRC have devised for this purpose. So it kind of looks at how they're contracted and how they're working. It's all how they're working for the actual client. So it's all, the majority will be to do with supervision, direction and control. So who has control over the kind of work that the contractor is doing, but there are additional factors that have to be considered, like financial risk and the ability to take on multiple clients while they're working. HMRC have a CEST tool, which is the Check Employment Status for Tax tool, and their own IR35 helpline. IR35 is generally all based upon case law. So as I said, it can be supervision, direction and control, but the additional factors are in there, and it's different in every single circumstances, which is why assessments are so important. So the CEST tool is there and functioning, but might not be incredibly accurate as it doesn't take into some big pieces of case law, mutuality of obligation being one of them. And as much as HMRC say they will always abide by their CEST tool assessments, as long as the information is accurate and honest, then that's great. However, it doesn't completely cover everything that we want an assessment to cover. So sometimes the answers can be a little bit vague. There's plenty of other tools available. I'm sure everyone's familiar with many that are floating around and have been in the last year. And they all tend to have little strengths and weaknesses, but the majority of them will also take into account case law. And one that we're going to talk about a little bit later on in this presentation will do that as well. Okay, so the changes for April 2021, as of the 6th of April, are when the rules get rolled over into the private sector. We've had that lovely 1-year grace period, which I don't think anybody was really expecting when it got announced last year, but it's been kind of helpful to have. So some of the changes that are coming in mean your medium-sized and large businesses are responsible for working out the contractor's employment status, not the contractor. The contractors all have to be given reasons behind the decision, and they can dispute it if they don't think it's correct. Small businesses are exempt from these changes. So if the contractor works for a small client, the contractor will still be responsible for working out their employer status, not the client, but that's only for small businesses. And there's some criteria that people have to meet to be a small business, to do with turnover and how big their balance sheet is, and have a certain number of employees. In this case, it's normally under 50. So that can have an effect as well. So it's important now that we're rolling through February that everyone, businesses, contractors, your clients, everyone starts preparing for this now, because it's not going to get delayed and it's only a matter of a couple of months away. So everyone should start working on this now or as soon as possible. Okay, so guidance of 2021. Some things have been changed in the last 12 months. So predominantly the rules are now law. We've had the Finance Act 2020 come in, and that's made all the changes that are coming in firm, and we know that they're going to happen. The Section 610 updates are about individuals and entities and people who might be trying to form an intermediary. So it goes back to what I said earlier about how they identify what an intermediary is. And basically this guidance that they've put in now, this update, is to stop people grouping together to form an intermediary, because that was starting to look like a little bit of a loophole. There's new PAYE and national insurance regulations as well. So it's extended recovery powers from HMRC for deemed employers who are not the feed payer. In case that's a little bit confusing, because it was to me when I first read through it. The fee payer is the fee payer who pays the fees for the work being done. But the deemed employer is somebody that the HMRC can kind of recognize as somebody who will be liable for the fees instead if there's an issue. So if the status determination gets stuck when it's going down the chain, if it's not passed on correctly, wherever it last sat, that person or group or entity becomes the deemed employer. And then they will be liable for any tax or national insurance deductions along the way. So when you do these assessments, they need to come down the chain correctly to everybody and get approved by everybody, because if they get stuck, then there's a bigger problem. So that communication is really important. There's also new guidance by HMRC available on their website around things like reasonable care. And that can be making sure it's the right person doing the assessments and checking the assessments, that the person's qualified to do them effectively, that it's not someone else doing them on behalf of somebody else, because that would show it's not reasonable care, and HMRC will be able to come back and argue against it and cause some recovery powers to be activated. And there's anti-avoidance provisions, which can be like outsourced provisions. So a statement of work is a great example of this. So if it's not a genuine outsourced service that is providing these statements of work, the risk of the assessment being wrong is higher, just like I just mentioned. If the wrong person or the not qualified person is doing the assessment, then that can cause a problem as well. Liability for taxes and NI will move if there's no reasonable care, as I explained as well. So it would look like a false assessment with incorrect information, and it would cause further problems along the way. And I think that covers all my legal bits that I needed to get done. So now I'm going to hand over to Chris, who's just going to run through some further information about IR35 from JSA. Thanks, Chris.
Thanks very much, Alex. Good afternoon, everybody. Yes, I'm going to run through just a few of the areas that we've already heard about, partly from Alex, just in and add a bit of real-life examples of what might happen, and yes, summarise where the risk now lays in the supply chain. So if we can just have the next slide quickly, please. So I'm just going to go over who I am and why I'm talking about this. The risk to the supply chain, the new responsibilities of end clients and indeed other parties in the chain. Then I'm going to quickly show you just a little example of how our assessment tool works. So this is a tool we've developed at JSA that can assess status for a contractor and also helps the supply chain manage contractors to ensure, for example, that they all have an assessment if they need one. And then just a few other examples of what we've been doing to help and how we're working with people like Xcede. So if we can move on to the next slide, please. We won't stay on this long because it's a big picture in my head, but the reason I'm talking about this is because I'm a chartered accountant, was an auditor, got involved with the FCSA, the Freelancer and Contractor Services Association, in 2017 because JSA are members of them. Got elected to the board and then became chairman. And because I work with that organisation, I work with the people at HMRC who write this law. Doesn't mean I necessarily agree with the way they're doing it, but I do have a good insight into what they're trying to achieve and what situations they want the legislation to work and how they think that should play out. So that's why I'm talking about it today. So if we just move on to the next slide, please. So obviously what these regulations do is add new risks to the supply chain. So what do they look like? Well, the end hirer is responsible now, or under the new rules, for the assessment of status, as we heard from Alex earlier. But the agency, the recruiter in the supply chain, is liable normally first for the payment of unpaid taxes if HMRC successfully challenge the assessment. And it's worth just pausing on that for a moment. If a supply chain continues to pay a PSC outside IR35, so it just pays its invoices, doesn't deduct tax, that doesn't make that supply chain immediately liable. What would make it liable is if HMRC are later able to come along and say, well, that assignment, I actually think that was inside. The supply chains treated it as outside, but I think it was inside. That's the point at which HMRC would then come to collect money. And the point there is they would first go to the agency, the fee payer, as Alex mentioned earlier, but then they do have powers as well to go elsewhere in the supply chain in certain circumstances. So the end hirer is taking responsibility for deciding status, whether it's inside or outside. And I've just got a couple of examples that normally help people to understand what this means, because of course this is at the core of this. Are you inside or outside? But what does that really mean? And I've heard stories about what inside and outside means, but what are the facts? So a couple of questions I get regularly. Is it true that if you've got a long assignment, if you're working with one end user for a long time, does that mean you're definitely inside IR35? And the answer to that is no. There's no time limit that makes you inside. But what is true is the longer that you work with one end user, the more likely it is that your working practices, the way you carry out your day-to-day, the way you deliver your services, is more and more likely to appear more and more like an employee would work. So the risk of you then accidentally starting to work like an employee, even if you didn't at the beginning, increases with a longer assignment. But there is no time limit. There's nothing like 2 years means you're inside or anything like that. So that's the answer to that one. If you have more than one client as a contractor, so if a contractor is servicing more than one client or regularly moving between end clients, does that mean they're definitely outside IR35? The answer to that is no, unfortunately. But what is true is that the more regularly you move from end client to end client, or if you do have several end clients at once, generally speaking, you'll find that a contractor who works like that will be more deliverable focused, will be more based on just doing the output for one piece of work and not creep into other things, and therefore is more likely to remain outside IR35. If your contract says you're not an employee, does that mean you're okay? No. If it was as simple as that, all contracts would say that, and that would be the end of the story. But the contract should reflect the working practices, but it's the working practices that are actually in place during the assignment that will decide whether the assignment is inside or outside. So the working practices, whether they're the working practices of an employee-like person, or were they the way a third-party business would operate in conjunction with the end client. And finally, one more that I get asked a lot is, if my agency, my recruiter, can substitute me, does that meet the substitution test that you sometimes hear in employment status? So that rule is that if, for example, I contract via Chris James Limited to do a piece of work for somebody, could I, if Natalie was suitably experienced and qualified to do so, could I send her instead? And that would be up to me. Is that, do I have the right to do that, and would the supply chain accept it? If they would, then that suggests it's not a personal service contract. It's not just me that could carry out the work. That means it doesn't sound like I'm in an employment relationship. So the question I mentioned was, my agency can substitute me. Does that mean I'm outside IR35? And the answer to that is no. It's not the agency that should be able to substitute you. It's you, the contractor, Chris James Limited, who should be able to substitute Chris for someone else without the end user deciding whether or not that's okay. So important point there as well is that substitution clauses, which have often been relied upon on employment status, there are actually quite limited situations normally where they will work in full. So what you don't want to do is rely on an outside status purely relying on substitution right. It can be the case, but it's quite unusual. So back to the main slides. So when the end hirer has made that decision on status, it's collected information about how the assignment will be carried out and decided, is it employee-like or not? Is it inside IR35 or outside? Then they'll have to issue that decision on a status determination statement, an SDS. And as Alex was mentioning earlier, so they make the decision, they have to pass this SDS to all the right parties in the chain. Otherwise, that end user never passes tax liability anywhere else. They remain responsible. So they're treated like the fee payer, even though they're not. So what they should do is pass that SDS to the agency, the next agency in the chain from them, and to the contractor or the contractor's PSC. And that's so that either of those parties could object if they need to. In theory, if they issue an inside IR35 SDS, then they've done everything they need to. If the agency and any other agencies in the supply chain then ensure that that contractor is paid via PAYE and taxed like a normal employee, for example, through a compliant umbrella company. So what we're saying there is not just through an umbrella company, but through an umbrella company that's doing tax properly, then there should be no liability or risk for anyone, because if HMRC were to come along and say employment tax should have been suffered here, it was suffered when the worker was paid. If the end hirer issues an outside IR35 SDS, then the supply chain can carry on as it does today in terms of payment. So the end user will pay the agency and the agency will pay the PSC. JSA can assist with ensuring that the supply chain meets its new obligations, because although those payments can continue as they do, the SDS and so on the assessment must be done properly, and the SDS must be passed down the chain. Otherwise, the tax liability could still sit in the wrong place. Can we have the next slide, please? So the end user, in summary, then has passed liability on if it does an assessment properly using reasonable care and passes that down. The agency passes liability on if there are other links in the chain and it passed the SDS, so it receives an SDS and passes it on to the right place. And if there's a separate fee payer, so separate for the agency, which occasionally happens in supply chains, and tax wasn't deducted from the invoice and HMRC think it should have been, then they'll go to that fee payer first. But if they can't collect from the fee payer, and that could be because the fee payer is going bust, then they can go to the agency nearest the end user, so the agency at the top of the chain next to the end user. And if they can't collect there, then they do have the rights in this legislation to then go to the end client. So overall, there's no way to completely remove liability, because it would be possible, for example, if the end user issued an inside SDS, passed it down the chain, but the chain didn't deduct tax, that liability could end up being chased up to the end user. So we have the next slide, please. So your new responsibilities, the end client has a responsibility to make the determination and pass it on, and evidence that they have done that and passed it on. They will become the fee payer if they don't do that, or if they do the assessment without using reasonable care. And this word appears a lot in the legislation. Broadly, what it means is taking a serious approach to IR35 off-payroll compliance, and making sure, for example, that each assessment is done properly based on the details of that assignment. The client will be also required to implement a status dispute process, because the contractor and certain other parties in the chain are allowed to dispute a status determination. That doesn't mean that it has to change, but if they dispute it, the dispute has to be answered specifically to confirm that the status assessment was appropriate, or amend it if it wasn't. For the agency, they'll be classed normally as the fee payer, because very commonly there'll only be one or two agencies in the chain. And they'll be responsible for deemed salary deductions. So that means they'll look at the invoice value and have to account for employees and employers, national insurance, and PAYE tax, and the apprenticeship levy, if appropriate. Could we move to the next slide, please? So how do you reduce the risk overall as a supply chain? As I mentioned before, HMRC are only going to come chasing tax if tax wasn't deducted, and it should have been. So if an accurate professional assessment is done, there shouldn't be a case to answer. And what I mean by that is your supply chain will only be paying people outside who should be paid outside, and therefore there shouldn't be any tax to chase up, because the assessment was accurate, or at the very least you'll have minimised the number of situations where HMRC could have a claim to make. If the fee payer is following a procedure, as in they've got a procedure to make sure they receive SDSs and act on them, and if the whole supply chain is properly insured, and that doesn't necessarily mean new insurance, but it may do, they shouldn't have a liability transferred to them, because insurance should fight to pay a strong case, and therefore HMRC, like I said, they can't just say, I want some tax and collect it. They have to prove that they have a case. So insurance often will fight a case on behalf of the agency or the end user. And of course, the other thing to reduce the risk would be making sure you've got that documented process for handling status disputes, because what you wouldn't want to do is to do everything right and then not notice that someone's disputed status, and after the time limit, which is 45 days, then suddenly all the liabilities have sat back up with the end client. Could we have the next slide, please? So this, if you can press play, if you're able to. Oh yes, we've got some sound. Oh. So I'll let the sound play if the video plays.
All users of IR35 Complete have the ability to create an account so that they're able to view their dashboard later. This includes the agency, the end client, and the worker. Here you can see how easy it is to set up an account. We've made it as simple as possible to complete assessments and update the whole chain. This starts with the agency user creating a new assessment request. They enter details about the end client and the role in question before entering the worker's details on the next screen. You're able to run an assessment without a particular worker in mind, so this will help at advertisement stage as well. You can see how simple it is to complete the information requested. Once submitted, the agency user will see a confirmation screen. The end client user will receive an email inviting them to complete a series of questions. They are able to reassign the invitation if they aren't the correct person. The assessment questions are thorough whilst being as simple as is possible, designed to determine the IR35 status of the role. Once submitted, the end client user will see a confirmation screen. There will be a prompt to create an account, as this will allow the user to easily view the status of each role every step of the way. This information can be filtered and exported. The agency user will receive an email requesting validation before an email is sent to the worker. Here we see the worker's portal screen and status determination statement, where a full explanation is available. From here, the worker chooses how they'd like to engage on the contract, with a list of umbrella options.
So there we are. That's just a quick demo of how our IR35 assessment tool operates. But the key there is it goes through a list of questions as other tools do. Again, as Alex was mentioning earlier, based on case law over the past 50 or 60 years. But then also it enables a supply chain to manage the flow of contractors to make sure that the contractor receives a status and then is able to select a way to engage that will be in line with an end user or an agency's list of preferred suppliers or approved suppliers list. So we can just have the next slide, please, which is the last one of the JSA ones. So yeah, what we're trying to do to help, we can meet with your teams internally or contractors to help them understand the changes. We can share content with you that you can use to explain things to contractors. Contractors, understandably, are in many cases very concerned about these changes because they don't yet know exactly how it's going to affect them. So it can be very helpful to have a third party there to explain what the rules are and just to be a neutral body to help you in your discussions with them. We can provide indicative status assessment. So that tool that you've just seen, as it was mentioned, it can assess a role, although it won't be complete until the contractor doing the role has been identified and joined in that process. But therefore, you can get indicative status assessments, which might be very useful if you've got a population of contractors and you don't yet know whether they might be inside or outside IR35. We can provide illustrations, of course, to show take-home and umbrella take-home. So again, contractors who are faced with having to work in a different way will want to know in pounds and pence what the impact's going to be on them. So we can supply detailed illustrations of that and talk them through those. We can help PSC contractors who it looks like aren't going to be able to use their PSC outside IR35 anymore to close their companies tax efficiently, if that's what they want to do. Depending on your circumstances as a contractor, it may or may not make sense to close your company quickly. And yeah, we can give tailored advice to those individual PSC contractors. We can help PSC contractors to migrate smoothly to umbrella where that's necessary, if that's what you have to do. Obviously, for many supply chains, there might be a mix of this. There might be some PSC contractors who can continue, and therefore you need a good assessment tool and workflow process to make sure you can evidence that you've complied with legislation, or you might have populations of contractors that just need to go to umbrella. We JSA's expanded rapidly over the past 5 or 6 years, and so we quite often had large populations of contractors to move from one engagement method to another. So we're used to doing it, we're experienced in it, and you know, we're good at it basically, so we can help you with that. And yeah, overall, we will discuss the individual circumstances of an end client or an agency or a contractor, but we can offer a range of options under one roof. So hopefully we're very well placed to help people to negotiate the various challenges that this new legislation brings. So if we can have the next slide, I think we're on to the question and answer section, which I'm sure everyone's very relieved to have got there.
Lovely, thanks a lot for that, Chris. So hi everybody, my name is Natalie Long. I'm one of the account managers at JSA. So we've been working with contractors on all of these changes for the last few years. I personally spent some time, a lot of time last year up in the banks with contractors who were being forced to switch from limited companies to umbrellas. So we should be able to answer any questions that you've got. So if you do have any, if you just want to write them in the chat box, we haven't got any in there at the moment. So we do have a few questions that we get regularly asked. So Chris, what I'll do is if I read the question, if you're able to answer that for me. So sure. Something that we get asked a lot is how often should we revisit the CES tool or status determination for a contractor? Okay, so there's bits in the legislation and then there's probably kind of a good underlying guide. So in the legislation, you need to do an assessment at the beginning of a new role. For an existing role, you would do one as you approach the 6th of April so that you can pay under the new legislation. And the other times are if an assignment is extended, so if someone was contracted for 6 months and then that's extended, you should reassess. And if any important circumstances change about the assignment, so say the way that the contractor was being supervised changed, that could be significant, so that should prompt a reassessment as well. If nothing much is changing and it's a fairly long assignment, then most people are settling on reassessing every 4 or 6 months. I think 6 months is probably reasonable, provided you're also aware of the fact that if circumstances change, that might trigger another assessment as well. Because if all the conditions stay the same, then probably every 6 months ought to be reasonable. Lovely, thank you, Chris. Something else that we get asked as well quite a lot is contractors are very concerned that if they've been working outside of IR35, say for 2 or 3 years or a number of years, and now suddenly they are staying on the same contract, they are concerned that HMRC would look back now they're being treated as inside. Is that the case, Chris? So it's a totally reasonable concern for a contractor. You can very easily understand that if someone has been, if someone's assessed their own status and believes they are outside and has treated themselves that way, then they're going to be upset, A, that an end user can't get themselves happy that that's the situation now. That's one thing, but you might accept that, except then you might worry that what about, is that going to impinge on my status in previous years? So there's no way to completely get rid of that worry, but what I can say is HMRC have very publicly said that they will not use an end user's determination as the trigger to open an inquiry into your past IR35 status. So in short, just because an end user now says, I think you're inside IR35 on my assessment, which of course might have been made on a completely different basis to how the contractor assessed their own status. It may include more or less information, or be better or worse. That in itself, that fact that now you're being treated as inside by somebody else, that can't be used as a trigger to open an investigation into you, or an inquiry. If that doesn't mean HMRC won't inquire into earlier years of yours, because of course they're not going to give carte blanche and say we'll never inquire into anybody going back. But what they have said is just by just the fact of that inside determination by an end user, that in itself won't be allowed to be a trigger for an inquiry.
Great, thank you. Something actually that has been coming up more and more, weekly, monthly, is if contractors are working overseas, can they still work outside of IR35?
Well, yeah, there's various ways to answer that question. I suppose if we just touch on international supply chains first. So if you've got a situation, it's not unusual for a supply chain, which we'll simplify and just say it's end user, agency, and contractor with their PSC probably. Those three units, you could have a situation, for example, where the end user was overseas, but the work is effectively being delivered at least from the UK. In that case, if the end user has no permanent relationship with the UK, then the new off-payroll rules don't apply. So in that case, the contractor, the PSC, would apply old IR35 as they have been doing today. If the contractor is overseas, then it depends on the technical point of whether or not that individual contractor, so say the Chris in Chris James Limited, is Chris resident for tax purposes in the UK. Because if I'm not, then in fact, new IR35 and old IR35, so the old IR35 rules and new off payroll, neither of them apply, because what they actually intend to do is to ensure that Chris James, the individual, pays the right amount of tax. If I'm not a UK tax resident, actually these rules don't apply to us at all. So with those two caveats, it's possible for someone to work overseas outside IR35, but exactly how that works, it might be that it doesn't apply, or it might be that the end user doesn't qualify, etc. Then, yeah, yes, you can, to the extent you can at the moment, you still can work outside IR35 abroad, but it's a more complicated question than that, if you see what I mean.
Sure, lovely. And we've just got a question from the webinar. What information is required to defend a HMRC challenge?
Well, if we divide that into two parts, there's how would you argue with the revenue over status? Well, that's going to be collecting all the factors together that you would use through case law, which would be the way that the contractor's controlled, whether there's a substitution clause, mutuality of obligation, and the other financial tests and so on that Alex mentioned earlier. That's defending status, but then for these new rules, there are important things that you've got to be able to demonstrate as a supply chain. So for example, as an agency, you'd have to demonstrate that you were aware of the rules, you tried to comply, possibly had a project team or something like that. You might have added things to your processes to ensure that you were able to comply with the new rules. You'd want to be able to show that you had a process for tracking SDSs coming in and then ensuring that they were supplied out if there was another party in the chain. You'd want to make sure you could demonstrate there was a process for recognising a dispute from a contractor and ensuring it was replied to in a certain period of time. And for example, recognising an extension of a contract and meaning that you as the agency, if that's who you are, can help the end client to remember that they need to do a new status assessment. So defending your activities under the new law with HMRC is a case of showing that you've taken the situation seriously. Possibly you've got a project team on it, or if you're a small business, it might be showing that you've gone to appropriate external advisors to give you help. And then having an audit trail of all this stuff is what's crucial to show the revenue that you've followed the processes in real time once the legislation comes in April. And again, that's another thing that our tool would help you with. It will, when you do the status assessment, it will make sure that you are prompted to send the SDS to the right places, and it keeps a record of that. So that you've then got evidence to show HMRC later that you've been doing your best to comply with the legislation. There is, if anyone wants any other detailed guidance, if you were to Google ESM 10,000, that's the revenues list of guidance around this legislation, and it includes a page on what are reasonable steps for an agency or an end user to take to demonstrate that they're taking the legislation seriously.
Great, lovely. Thank you, Chris.
I didn't know how to write this down, so I'm just going to say it. Obviously, we can do status determinations through a tool and have that documentation there. But we also, there's a big factor of actual physical working practices. How do we demonstrate that, and how do you keep a record of that for the HMRC to prove your working practices are in line with what you're saying on the status determination?
Good evidence of that is the same evidence that would have been good for, for normal IR35 over the last 20 years. So there are things like, for example, one of the things that sometimes gets argued around about status is substitution. And I mentioned earlier, there's actually limited circumstances where it can apply, but it can sometimes. And so good evidence there would be not just that it's written in the contract, but that if it happened occasionally, you might keep evidence of that. So you might build a kind of case file. Oh yeah, here's where that happens in this supply chain. It does happen sometimes. If there's evidence of, for example, control or making sure that the contractor isn't getting absorbed into the end client's business, then you might keep evidence, for example, at the end that contractor's not being invited to, works events, hasn't got the same right on site as employees have, and things like that. So it's keeping documentary evidence that supports the working practices that we're relying on when we're reaching the outside status. Just any evidence you can keep that that demonstrates that. Just as a side point, the way it's assessed if it ever goes to court, and obviously very few cases ever actually go to court, but in court, what would happen is, if, for example, a contract says this worker won't be controlled in any way, they won't be supervised significantly, they're absolutely left to their own devices, then court would look at that and say, did that happen? And it would interview people in the supply chain and say, was that the case? Were you managing and controlling this person closely, or were they allowed to operate under their own devices? So that's kind of questions that a court would ask. And so evidence that supports that would be a great thing for a supply chain or a contractor to keep as their case file of IR35 status confirmation.
Right, and in your experience, Chris, and all your dealings with HMRC, what do you think they're trying to achieve? Do we think that they are looking to put everybody inside and collect tax, or what's your opinion?
Yeah, it's very important that. No, they're not trying to get everybody inside. It's fair to say that if they got more people inside than perhaps should be inside, obviously, it would be reasonable to suggest that they wouldn't mind that very much, because they're collecting payroll tax every month instead of collecting corporation tax and dividend tax and VAT and so on a slower basis. But HMRC themselves have confirmed repeatedly that they think around 1/3 of PSC contractors are inside. The problem they had was that around 3% were treating themselves as inside. And that's where the figure that, again, is often quoted of 9 out of 10 people aren't complying. What it actually meant was, if you take that 33%, only 1 in 10 of those were saying they were inside, and the revenue believe all of those 33% were inside. But that still leaves the majority of contractors, the 60-something%, as genuinely outside. So they should be able to continue to work outside. HMRC, what they were aiming at was, in some sectors, a large number of effectively temporary employees had ended up being put through limited companies because there was a marginal tax saving on that. And that obviously saved the supply chain money and gave a bit more money to the contractor. HMRC saw that happening too often in certain areas, and I think we all know the kind of sectors where that might have been happening. What they were trying to do is collect tax from those people. That's what they were after. And in fact, to an extent, even though the rules were delayed last year, there were so many blanket determinations is the wrong word, perhaps an emotive word, but so many of the banks made a policy decision to not engage with PSCs anymore, that thousands of contractors stopped working through their own limited company. And that will have certainly been one of the sectors that was in HMRC's crosshairs when they imagined putting this legislation in. So in many ways, even though the law's not in yet, it's already had a significant part of the effect HMRC probably wanted.
Okay, just a few more questions now coming up. So from the webinar, can I stay a limited company, or do I have to change to umbrella?
So under the law, you can stay as a limited company, but in order to do that, you then need to be paid by a supply chain that's happy paying you with deemed deductions. So what it would do is it would pay your invoices, but it would deduct employment taxes from that, and probably your rate would have to be renegotiated and so on. And for some contractors, therefore, they think, well, shall I do that and still have the admin cost of running my limited company and have no employment rights whatsoever? Or should I look at a PAYE option like agency PAYE or umbrella, where I will accrue employment rights over time like other employees,
So I'll still be paying a similar amount of tax, but at least I am recognised an employee and get employment rights. So it's possible to do it under the law. For each contractor, it's going to depend on what their supply chain is prepared to engage with, because some supply chains might take the view that if they've got to put a system in that's going to enable them to pay 1 or 2 contractors through their limited company on a deemed basis, that might not be something that they want to engage with if the contractor's not going to be worse off pound for pound by being on an umbrella or a PAYE model.
Okay, great. And another question from the webinar: what are the rules for paying employers' taxes and national insurance under an IR35 booking?
Not sure exactly what the question is driving at, but in terms of if someone's working outside IR35, then and that's correctly being done, then the only employer's national insurance responsibilities they'd have would be on the salary that they, as the contractor, are taking out themselves. And what most contractors do is they take out a level of salary that doesn't quite or only just triggers employers' national insurance contributions. If you're working inside IR35, then effectively the supply chain is going to pay you as an employee. So the money moving through the supply chain is going to have to include employers' national insurance. And so if you've got a rate that's going to be paid to someone who's going to pay you as an employee, that rate's going to have to include employers' national insurance and apprenticeship levy if appropriate, and so on. So that's just a case of, the reason for that is that this is about understanding what the rate is that you're being quoted in the first place, knowing whether it's a rate that's intended to cover your gross pay and all employment taxes, or if it's a rate that's being paid to you as an outside contractor, and therefore it's very much up to you how the taxes accrue, because it's your business to pay yourself once the limited company's received the income.
Okay, great. So just one other question that we've had as well is, if the rate is the same, then nothing needs to change. Is that right?
I wouldn't say that, certainly, because one thing that's very important here is if someone's moving from working through their own limited company and then because of these rules, they end up then working through an employed method. In the rules, in the law, it's kind of implicit that the idea is that whoever's paying the worker needs to make an adjustment for employers' national insurance. And therefore, if nothing changes about the assignment at all, the contractor would have, or certainly would have, you could understand them feeling like they've had employers' national insurance taken out of their rate. But what they should understand is that now they're on a new rate and the rate is made up in a different way. The old rate of tax, the old rate of pay was intended to meet all the taxes that were due through their limited company. If they're now working through an employment method, that new rate has to cover all the taxes that are due under employment. It's very, very important that an agency or any part of the supply chain is clear with the contractor that their engagement method is changed. This is a new engagement and this is a new rate. Even if the rate is very similar to the old rate, it's made up in a different way. It covers different things. It's not the same thing. So yeah, in some ways I could say, no, absolutely not. It's very important. Everyone in the supply chain knows that the engagement method has changed. If we've moved from working through a PSC to working through an employed method, because if that's not done, the contractor may well have at least a moral case for saying, well, hang on a minute, now you're taking money out of my rate. They need to understand how their new rate's made up and what it does and doesn't include.
Sure. Okay, great. Thank you, Chris. So I think that's all the questions now. Just to let you know, we will share the slides with you as well. And I'll just hand back to Martin just to summarise and finish up. Thank you.
Thanks.
No, yeah, so I don't think there's much for me to say. I think it's just a case of thank you very much for all coming along. And yeah, if there's any questions, please follow up with us. We've put emails in there and, we'll be following up for your feedback as well. So, appreciate everyone's time and questions. And, thank you to Natalie and Chris for taking time out of their day to help us with this. And, hope to hear from you all soon.
Great. Thank you very much, Martin.
Thanks.
Bye all.